ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
ತುಂಬಾ ಪ್ರಾಬ್ಲಮ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಈ ಕನ್ಸೋಲ್ನವರು.
ಹೌದೌದು,
ಬಹಳ ಪ್ರಾಬ್ಲಮ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಸರಿಯಾಗಿತ್ತು, ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಬೇಕು.
ಅಲ್ಲ, ಈಗ ನಾ ಹೇಳ್ತಾನೆ ಇದ್ದೇನೆ, ನಾವೆಲ್ಲ ಸೇರಿ ಒಂದ್ಸಲ ಏನಾದ್ರು ಹೇಳಿದ್ರೆ
ರೆಡಿ ಮಾಡಿ ಸರ್, ರೆಪ್ರೆಸೆಂಟೇಷನ್
ಭಾರಿ ಪ್ರಾಬ್ಲಮ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಹೌದು, ಇದ್ದಕ್ಕಿದ್ದಾಗೆ ಕನೆಕ್ಷನ್ ಹೋಗುತ್ತೆ.
ಎಲ್ಲದಕ್ಕಿಂತ ಮೇನು ಒಂದೇ ಡಿವೈಸ್ ಅಲ್ಲಿ 3-4 ಕೋರ್ಟ್ ಅಟೆಂಡ್ ಹ್ಯಾಂಗ್ ಮಾಡೋದು ನಾವು?
ಆಗಲ್ಲ, ಇದ್ರಲ್ಲಿ ಆಗಲ್ಲ.
ಇದು ಬಹಳ ಪ್ರಾಬ್ಲಮ್. ಇದು ಬೇರೆ ಬೇರೆ ಡಿವೈಸ್ ಕೊಡ್ಲೇಬೇಕು. ಮೊದಲನಾಗೆ ID ಕೊಡ್ಬೇಕು ಅವ್ರು.
ಹೌದು. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಏನಕ್ಕೆ ಸರ್ ಹಾಕಿರೋದು? ಬರೀ ಆರ್ಡರ್ಸ್ ಅಂತ ಇದೆ.
ಕೇಳಿ ನೋಡಿ, ನನಗೂ ಗೊತ್ತಿಲ್ಲ. ಬಹುಶಃ ಇದು ರೆಫರ್ ಟು ಲೋಕಾತ್ ಲಿಸ್ಟ್ ಆಗಿರ್ಬೇಕು.
ವಾಲ್ಯೂಮ್ ಅದು ಸ್ಪೀಕರ್ ವಾಲ್ಯೂಮ್ ಸರ್. ಇಟ್ ಇಸ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ಲಿ ಸೆಟ್ ಬೈ ದಿ ಸಾಫ್ಟ್ವೇರ್ ನಲ್ಲಿ ಕಾಮನ್ ಆಗಿ. ನಾವು ಕಡಿಮೆ ಅಂತೀವ, ಕೆಲವು ಪೋರ್ಟಲ್ ಜೋರಾಗ್ತದೆ. ಅದಕ್ಕೆ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಕಾಮನ್ ಆಗಿ ವಾಲ್ಯೂಮ್ ನ ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೆ ಸ್ಪೀಕರ್ಗಳಿಗೆ. ಅದನ್ನ ನಾವು ಕಂಟ್ರೋಲ್ ಮಾಡೋದಿಲ್ಲ. ನಮ್ಮ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಬೇಕಾದ್ರೆ ನಾವು ಕಂಟ್ರೋಲ್ ಮಾಡ್ಬೋದು. ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಕಂಟ್ರೋಲ್ ಆದ್ರೂ ಅದು ಅಷ್ಟೇ ಇರುತ್ತೆ. ಅದೇ ಸರ್ ಹೇಳಿ. ಮೋಸ್ಟ್ಲಿ ಅದು ರೆಫರ್ ಟು ಲೋಕದಲ್ಲ ತರುತ್ತೆ. 5 ನಿಮಿಷ ವೇಸ್ಟ್ ಮಾಡಿ. ಕಾಮನ್ ಆರ್ಡರ್ ಆಗುತ್ತೆ. ಅದು ಮೊನ್ನೆ 2 ಲಿಸ್ಟ್ ಆಗಿದೆ. ಆ ಥರ ಟುಡೇಸ್ ಲಿಸ್ಟ್ ಆಲ್ಸೋ ಇಟ್ ಈಸ್ ಲೈಕ್ ದಟ್. ಇದ್ಯಾವುದು ಇದು? ಅದಲ್ಲ ಸರ್, 2 ಲಿಸ್ಟ್ ನಂಗೆ ಕೊಟ್ಟೆ. ಅಲ್ಲಿ ಇಡಕ್ಕೆ ಮೇಡಮ್ ಗಿಡಕ್ಕೆ ಇದೆ ಅಲ್ವಾ? ಒಂದು ಕೊಟ್ಬಿಟ್ಟಿರು ನಂಗೆ. ಹೌದು, ಅದೇ ಲಿಸ್ಟ್ ನಂಬರ್ 2ನೇ. ಇನ್ನೊಂದು ಕೊಟ್ಬಿಡು ಮೇಡಮ್ ಕೊಡಕ್ಕೆ, ಚೆನ್ನಾಗಿ ಕೊಡಕ್ಕೆ ಅಲ್ಲಿ ಇಟ್ಕೊಟ್ಟು. ಆಯ್ತು.
ಮೇಡಮ್ ಕೋರ್ಟ್ ಮ್ಯೂಟ್ ಆಗಿದೆಯಾ? ಮ್ಯೂಟ್ ಆಗಿದೆಯಾ ಕೋರ್ಟು?
ಮ್ಯೂಟ್ ಮಾಡಿದೀವಿ ನಾವು. ನಮ್
ಹಾ,
ಮೇಡಮ್
ಸರಿ.
ಮಾಡಿರ್ತೀವಿ,
ಹೌದು.
ಆಮೇಲೆ ಮಾಡ್ತೀವಿ.
ಆಯ್ತು, ಓಕೆ.
ಇಲ್ಲಾಂದ್ರೆ ಎಲ್ಲಾ ರೆಕಾರ್ಡಿಂಗ್ ಇಲ್ಲಿ ಏನೇನೋ ಡಿಸ್ಕಷನ್ ನಡೀತಿರೋದು.
ಆಯ್ತು. ವಾಯ್ಸ್ ಬರ್ತಾ ಇಲ್ಲ.
The petitioner wants to withdraw the petition, my lords. A memo for withdrawal has been filed at the registry in Dharwad.
Want to withdraw the CP?
Yes, yes. A memo for withdrawal has been filed at the registry in Dharwad.
It is submitted that already memo is filed seeking withdrawal of the petition. In the light of the said memo, the petition is dismissed as withdrawn. It's
Okay.
no doubt. Call the list.
List number 1, parted matter, serial number 1.
No, all these final hearing stage parted matters will take it after this list. End of the
Your-
tomorrow. Why?
Lord, naming serial number 1, we called tomorrow. Afternoon, I have got some inconvenience.
Yes.
Now I am ready. Now that your lordship.
Yes, because it will take time.
I
the
know,
whole
but-
list. Yes.
I'm sorry, my lord. Your
Tomorrow.
lordship. Tomorrow.
Your Lordship,
Three also.
Your Lordship,
Two also tomorrow.
Your Lordship, item number 26 was specifically posted for tomorrow at 2:30 p.m. Councils are coming from out of station. It may be
I'm the petition.
26.
This is the
I'm
ship,
for
my lords. I'm the petitioner.
Yes, I remember that.
It has come today, my lords. It was supposed to come
Please,
tomorrow.
today.
Date was given to tomorrow, Your Lordship, specifically at 2:30.
Yes, it is submitted so and so. That's wrongly posted. That why it was directed to be listed tomorrow. That is so and so. List tomorrow.
At 2:30, Your Lordship, because the
Most grateful.
Your Lordship's kindly minute.
What will happen to all other matters tomorrow if it is at 2:30?
Your Lord,
2:30. It's difficult tomorrow. Then what we will do is we'll take up that matter on.
no, Your Lordship, the flight, they have already made travel arrangements and they have incurred the cost for travel. They're coming from Mumbai because the date was specifically given and it was specifically mentioned to be posted at 2:30. They have made the travel arrangements accordingly.
No travel arrangement is court should also have the time. List this matter on 16th of April.
It may be taken up, Your Lordship. There is an urgency and we last time also we had
No, it's
submitted.
not possible. Court has so many other matters. Your matter alone is not the urgency for the court. There are so many matters tomorrow. I can't take up. Yes.
My lord, may I make one submission, my lord? My lord, serial number 21.
Mr. Shastri, please wait for the turn. No, no mentionings now. Call the list.
List number 1, for this
Yes.
dismissal, serial number 8.
Not dismissal. Remaining matters can be called. The first matter is called from 4. Yes. 4.
Serial number 2. 5, 6.
Parted matters 1, 2, and 3 are posted to tomorrow. Call from 4. Who asked?
3 and 2.
Say no. Only 3 they asked, not 4. Call 4.
Serial number 4. Anumantappa A for appellant. A.M. Venkatesh.
Yes.
There are 3 cases. First case is for enhancement, and second case is, Madam my lord, the claim petition was dismissed, and insurance also filed an appeal.
Is it a case where one tribunal
Yes,
has
my lord.
dismissed?
No,
Same tribunal has
no, my
dismissed?
lord, different tribunal. Different tribunal passed different orders, my lord. One appeal is filed by the, one petition is filed by the inmates of the car, my lord. It was allowed and 40,000 global compensation is awarded. Another case, another tribunal, my lord, filed by the another inmate of the car, my lord. 12,000 rupees global compensation is awarded, but claim petition was dismissed.
Then
Then they filed an appeal
what happened to that?
to pass on the same order in passed by the other tribunal.
No, let's have the numbers first.
My lord, 84, 87 or 15 is challenged by the insurance
1
company.
minute. 84, 87 is
Yes.
arising out of?
MBC 105 or 14. That is challenged before this court, granting compensation to the
Your
extent of-
appeal is
9459.
9459.
MEC 105 of 2014 for enhancement. Another matter 4330 of 15. This is a claim petition was dismissed, my lord. That was challenged, my lord. The MEC
Arising out of?
same accident.
Same accident, my lord.
No, by a different tribunal.
Please, my lord.
MVC number?
174 of 14.
Now we will take 174 of 14.
Please, my lord.
Where is that?
174 14. That is 8487 MFA, sir.
4330.
4330. Let's see the order.
Please. Para 17 of the judgment, my lord. There is a discussion, my lord. Mainly relying upon the private investigator, my lord, the claim petition was dismissed, my lord.
Read from issue number 1 and 2.
Please. In order to prove the petition allegation, petitioner himself examined at PW1 and retreated the factual allegation made in the petition on oath. Para 10 in. Respondent number 1 3 have admitted the occurrence of the accident. According to the respondent 3, respondent number was not driving the car at the time of the accident. However, the relevant point of time, petitioner himself was driving the vehicle without valid and effective driving license. In order to prove the said contention, the respondent examined his officer as RW2 and the investigator as RW3. In support of this contention, got marked certificate copy of the photos, request letter, claim intimation sheet, MLC register, extract of petitioner, MLC register extract of one Raju, investigation report issued by the investigator, additional report submitted by the investigation officer, and hospital records at exhibit R1 to R8, 11 and 10 and 11. The learned counsel of the petitioner vehemently argued that the evidence placed on record it is sufficient to prove the occurrence of the accident. RW being the driver has clearly spoken at the time of the accident, he was the driver of the accident caused vehicle. The contention of the respondent 3 that the statement given by the one Raju produced at exhibit 15 is concocted and created on the basis of the said document. It cannot be said that the petitioner was the driver of the accident caused vehicle at the time of the accident. Hence, prayed to avoid the reasonable compensation taking into consideration the grievance of the interest sustained of the petitioner. The learned counsel of the respondent strenuously argued that at the time of the accident, the materials placed on record disclosed that the petitioner himself was driving the accident caused the vehicle. The insurance company investigated the matter through RW3, who has recorded the statement of Mr. One Raju, who was also inmate of the vehicle at the time of the accident. He clearly stated that the respondent was not the driver. However, the petitioner was driving the vehicle at the time. At the relevant point of time, the petitioner was not having the driving license. Because of that reason, the respondent was involved in the accident in collusion with the police official. According to the police record, there is a head-on collision between the KSRTC bus and Maruti Swift car. If really respondent number was the driver of the car, caused the act in the case, he must sustain injuries. Surprisingly, no injuries sustained by the respondent number 1. This fact creates doubt that the respondent was not the driver of the relevant point of time. He also drew the attention of the court about the photographs of the accident caused the car. As the petitioner was not holding the valid and effective driving license, and the petitioner in collusion with the police official created the documents and filed the false case petition, hence prior to dismiss the petition. Before appreciating the evidence and arguments of the learned counsel of the petitioner, respondent 3, I would like to note the caution given by the Honorable High Court Karnataka in decision reported ILR 2009 KR 2921. Caution not only the allow the claim petition which are genuine in nature, but at the same time the great responsibility on the part of the crimes tribunal to ensure that no false claims are allowed by it. Further, it is observed that the claims tribunals are required to examine the evidence before it very carefully, and merely because the claimant comes out of the evidence that the driver of the vehicle is convicted and is pleading guilty. The tribunal should not go by the plead guilty factor alone, but is required to appreciate the evidence before it from the every angle and make an assessment of the whole situation. In the decision reported in ILR 2009 Karnataka 3562, the Honorable High Court of Karnataka has held that fraud and justice never dwell together. In case of fraud by the claimants on a court in MUC cases, in connivence with the owner of the vehicle and police, insurance company cannot be made liable to pay the compensation. Keeping in mind the observation made by the Honorable High Court of Karnataka in the above referred decision, in the evaluate the entire evidence placed on record by the parties to the petition. In the present case, Respondent 3 has not disputed about the date and time and place of occurrence of the accident between KSRTC bus and the Maruti Swift car. The only contention taken by the Respondent 3 is that at the relevant point of time, the respondent was not the driver of the Maruti Swift car, but the petitioner was the driver of the accidental caused car. As the person who was driving the car was not holding valid and effective driving license, the respondent is involved in this case. In order to prove this contention, the advocate for the respondent focused much argument on the evidence of the private investigator who submitted the report that the respondent was not the driver, and secondly, the non-sustaining any injury to respondent in the accident creates doubt as whether really respondent was the driver of the car at the time of the accident. Now the question is whether the evidence of the private investigator is acceptable. The respondent number 3 examined private investigator Chandrasekhar Murthy as RW3. He has stated that he has submitted the report as per Exhibit P6 and additional report as per Exhibit P8. He also stated that he recorded the statement of inmates of the car. In the cross-examination, he has stated that he is a BCom graduate and working as an agent of respondent number 3 insurance company. He has no special skills to conduct the investigation. It is also come in the cross-examination that he has no document to show that respondent 3 appointed him as an investigator to investigate the matter. He does not know under what law is permitted to record a statement of the witness.
Yes, I have seen. So,
Please,
you are you are the inmate of the car. RW1 is the first respondent is the driver of the car.
Please, madam.
It is a head-on collision. The entire right side of the car is completely damaged. You sustained injuries being an inmate, and driver has not sustained any injuries.
Driver and another inmate of the car also not sustained the injury.
Only you have sustained.
Only.
And let us look at what are the exhibits marked on your behalf.
Please, my lord. First, my lord, the statement recorded by the investigation officer, my lord, Exhibit P R12, my lord.
Where is that MLC extract? Give Exhibit R4 and 5. What is the date of
MLC
accident?
extract not marked, my lord.
Date of accident?
Date of accident.
1/11/2012, my lord.
1/11.
2012.
Time of the time?
Twelve 15 p.m.
Complaint was given when?
Same day, Same day.
At what time? Where is the FIR?
At Exhibit P2, my lord. Exhibit P2 is a complaint, my lord. 15:30 by the KSRTC driver, my lord. Exhibit P3 is a wound certificate, my lord. Wound certificate, Exhibit P3.
MLC, they have not marked, my lord.
No, but if you look at the order, end of it, it says R4 and R5 are the MLC register extracts. R4 and R5. And in this kind of damage to the car, how come the driver will not sustain injury?
He sustained the simple injuries, my lord.
Where are you sitting?
He stated in his evidence, my lord.
No, where is he sitting?
Please, my lord.
No, if you're sitting in the backside of the driver, you cannot sustain injuries without the driver being injured.
There are 4 members in the car, my lord, including driver, my lord. One girl is there, my lord. She is also not sustained, and driver also not sustained. Other 2 was sustained injuries. Please, my lord.
Damage to the car?
Yes.
He sustained simple injuries, my lord. He ran away from the spot.
Then how did you sustain grievous injuries? When the driver had sustained, front side of the car is completely damaged.
He
escaped,
my lord. That is the evidence given by my
Please
lord.
come.
He is only relying of the, please, my lord. Exhibit P12, my lord.
And then what about it? Now assuming that he's the driver of the car.
My lord,
What should follow?
please come to judgment of the learned MSc, page number 7, para number 10.
That I have seen. I am convinced on that aspect.
Even after producing the dismissed case
Mr.
before the learned
Venkatesh, what I am
MSc.
asking is, assuming that he is driving the vehicle, that is the claimant is driving the vehicle. So what should follow? What is his entitlement?
The connected case is dismissed against the same MACT, but 2 different courts, that's all, my lord. Initially, the case was dismissed 6 months prior to.
We are taking your case for granted.
Please.
That the claimant was only driving the car. Claimant was only driving the car. He had sustained injuries.
Yes.
What is he entitled for then?
No, it's a fraud committed by the claimants itself, because Prasanna Kumar was not the driver, my lord.
That is one aspect.
Yes, Prasanna Kumar driving the car.
That I understand.
Yes.
Fraud is one aspect.
Yes.
Then
Fraud is committed by the claimants, so it has to be dismissed. On these grounds, I pray the sample.
no, the owner has given the vehicle
If
to,
at all, sir,
owner has given him to drive the car. He'll
it
be
is for the
entitled.
owner to pay the compensation to the claimant, if it is proved.
He is not, owner is not entitled for any personal accident coverage.
Yeah, coverage.
No, I have to see.
He will be entitled.
Yes, my lord.
And that whatever that is, let it be paid to the driver.
They have to see the policy, my lord.
Huh?
They have to see the policy, my
Look
lord.
at the policy.
Yes. Policy is not
Made any claim, alva.
Huh?
Owner has not made any claim.
Owner is not claimed anything before this court, neither before the MSc, my lord.
Kanala, sir.
Yes. Where is the policy exhibit?
Exhibit
Letter,
R9.
claim, intimation, investigation, policy copy exhibit R9. Yes. PA coverage 100 rupees. That is 1 lakh. 1 lakh.
To the owner, my lord.
No, this person has stepped into the shoes of the owner. The agreed with orders passed in MBC number 174 of 2014. Agreed with the dismissal of MBC number 174 of 2014, dated 25th March 2015. The claimant is before this court. The claim petition is filed seeking compensation for the injuries sustained by him in the road traffic accident. It is his case that on 1/11/2012, he was traveling in a car from Davangere to Bhadravati at about 12 p.m. when the car was proceeding in between Arikere and Arikere colony near Honali. At that time, the respondent number 1, being the driver of the car in which the petitioner claimant was proceeding, drove the same in a rash and negligent manner with high speed and dashed against the opposite coming KSRTC bus, thereby causing an accident. And in the said accident, the claimant and other inmates have sustained injuries. The tribunal had dismissed the claim petition on the ground that before that, it's a case of the insurance company that at the relevant point of time, the claimant was the driver of the vehicle as he was not having a valid driving license to drive the vehicle. It is shown that RW1, the respondent number 1, is driving the vehicle. According to the insurance company, the photographs that are placed before the court, that is the damage to the vehicle. The car, the right side front portion of the car is completely damaged. Admittedly, the driver of the vehicle, that is respondent number 1, had not sustained any injuries. It is stated that only for the purpose of claiming the compensation, and it is shown that it is stated that respondent number 1 is driving the car. The tribunal and the respondent insurance company had examined the officer and the investigator who has investigated the case. The court had not taken into consideration the evidence of the investigator appointed by the insurance company, but the court had considered as per the IMV report, the damage to the vehicle, and the driver has not even sustained any injuries, and only the claimant had sustained injuries, and court had disbelieved the version and held that he is not entitled for compensation. Then counsel appearing for the insurance claimant submits that the court ought to have granted the compensation. It is submitted that the entire evidence shows that the respondent number 1 was driving the vehicle, and he has also stated he was driving the vehicle. Court ought to have taken the same into consideration and ought to have granted the compensation. Next part. Then counsel appearing for the respondent insurance company submits that a fraud is played on the court, and he has come before the.
Please come to the first page of the learned MACT at Davangere 1. In the first respondent one, here they have shown it as Praveen Kumar. In 105, they have shown as Praveen Kumar. This was decided on 5th September 2015, whereas the second was decided 25th March 2015. March 2015 case, wherein we have produced.
In your both are before us, before this court, we will appreciate.
Yes, please.
It now.
Please.
What did you write? He has come before the court with all misrepresentation of facts, and the tribunal had rightly dismissed the petition. It is submitted that the court had rightly given a finding with considering the IMV report, and no injuries are sustained by R1, and had rightly come to the conclusion and dismissed the petition. Next, having heard the learned counsel, on either side there is a material on record. The tribunal had rightly considered the IMV report, and that no injuries are sustained by R1, and also rightly not considered the evidence or the investigation that is done by the private investigator appointed by the insurance company. The court observed that it is a transport vehicle. And there is no evidence to show that the respondent is engaged by the owner of the vehicle.
Private package policy.
If it is looked
tax
from
policy.
that point, that angle, where you have come to court, it's a client, it's kind of playing fraud on the court.
No, my lord. Kindly see, my lord.
No, please
Exhibit
understand.
R3, it was recorded by the investigation officer who is the investigating, was recorded the statement of the
That is not
driver.
considered, that is not considered. by the
Only on
tribunal.
relying upon the statement of the Raju, who is the inmate of the car, the tribunal has dismissed my claim petition. Kindly see the statement, my lord. Same date is recorded by the investigation officer. On 29/12.
I'm considering, and I'm of the view that the tribunal, findings of the tribunal are correct. No further discussion on that. No, initially I thought I'll give you that PSC, but in the facts and circumstances, even giving on that also is like entertaining false claims.
It's not a false claim, my lord.
It is a false.
Kindly see, my lord.
Either it has to, either you are entitled for a compensation or not. Now court, if the court says, okay, he has come to the court with all these facts, still will grant him PA.
Court has considered, my lord, is assessed the 12,000 rupees as a global compensation. Later, my lord, giving the operative portion, it was dismissed. It has to consider the case of the claimant.
Court has to, in cases, they will also decide the compensation, if at all. If it comes to this court and if you are entitled, why should we again remand it back? Will not grant the PSC also.
Here, a small amount is there, my lord. Nothing is there.
What did you write? And the court had rightly considered the evidence and rightly held that the accident had not, the claimant has not come to the court with clean hands. And this court has, the findings of the court are based on evidence, and the reasoning given by the court need not be interfered by this court. Accordingly, appeal of the claimant is dismissed. Next appeal.
Next appeal for enhancement, my lord. He's the inmate of the car, my lord.
Next matter, MFA 9459.
He was an inpatient for 6 days, my lord.
Now this appeal of yours is with respect
9459.
to 9459.
My appeal, my lord. So for enhancement. It's also, my lord, he sustained injuries, my lord. He was an inpatient for a period of 6 days. Doctor not examined. 40,000 global compensations awarded, my lord.
So what is the enhancement you're seeking on what ground?
6 days he was an inpatient, my lord. I have produced the charge, discharge summary, my lord.
No doctor examined, my lord.
No, doctor not examined, my lord. Doctor not examined.
Let us see that part of.
Please, my lord. Para 14 of the judgment, my lord. Issue number 3. Issue number 3, my lord. PW has claimed compensation for 5 lakh rupees from the respondent. In order to substantiate his case, PW has categorically stated before the court in the affidavit evidence by the retreating the arguments of the petition with regard to the alleged accident, injuries sustained and treatment taken by her in the hospital, and as well as the amount spent towards medical expenses. In support of his version, he has produced the medical bills of Exhibit P9 for tune of rupees 8,311 in the petition. The petition has contained that the injuries sustained by him are grievous in nature.
What are you doing in the hospital for 7 days for simple injuries?
6 days, my lord.
What are you doing in the hospital?
The treatment, my lord. They have sustained the injury, my lord.
The agreed with the.
Photograph I produced, my lord.
Agreed with the orders passed.
Parcel bonus.
MBC number 105 of 2014. Both the insurance company as well as the claimant are before this court. The claimant's appeal is MFA 9459 of 2015, and the insurance company's appeal is MFA 8487 of 2015. It's a case of the insurance company that in the very same accident, in respect of the other inmate of the car, the claim petition is dismissed, whereas in this petition it is entertained and granted compensation. The contention of the insurance company is not tenable. In that case, though he has stated that he is an inmate, the finding of the court was he was the driver of the vehicle. As such, the said claim petition is dismissed. That said finding of the court cannot be equated with this inmate, and on this ground, the insurance company appeal is liable to be dismissed. Then coming to the appeal of the claimant, according to the claimant, he had the claimant had claimed compensation of 5 lakhs. He has, according to him, he was in hospital for 6 days and he had sustained the grievous injuries. the court had perused the wound certificate, which shows that the injuries are simple in nature. And further, the medical officer who issued the wound certificate opined that all the injuries are simple in nature. And he has not examined anybody in support of his case. Hence, the court has granted global compensation of an amount of rupees 40,000. Interest at what percent?
6%.
40,000. When counsel submits that, the compensation that's awarded is not reasonable. The compensation needs to be enhanced. A perusal of the order discloses that the claimant had not examined anyone, nor the wound certificate and other documents which are filed by him are supporting the case of the claimant that he had sustained grievous injuries. In that view of the matter, the court had rightly granted the global compensation. This court finds no reason.
Kindly see photograph, my lord. Sustained face, my lord. Entire face was damaged.
Understand.
Entire face was damaged.
Court can't assume and presume things.
Because if a doctor not examined, it doesn't mean that you are not sustained grievance injuries. The face of the claimant, my lord. Client is the photograph.
Then why did you file the wound certificate which says your injuries are simple in nature? What to do? Yes,
there is no fracture, my lord. Face, my lord. Entire face was skin grafting was done, my lord. Therefore, you are 6 days inpatient.
Yes. Appeal is dismissed. Insurance company's appeal MFA 8487 of 2015 is dismissed, and claimant's appeal is also dismissed. Yes, next.
Cell number 5.
Yes.
Cell number 5, Nagaraja K. For appellant.
You're not audible, Mr. Nagaraj.
Nagaraj sir. Sir, unmute ಮಾಡ್ಕೊಳ್ಳಿ ನಿಮ್ದು ಮೊಬೈಲ್. Nagaraj.
Yes, madam. I am sorry. But this is awarding of loss of revenue caused to the KSRTC bus on account of the damages, madam. The tribunal awarded.
What is the material before the court to show the loss of revenue?
Loss of revenue, madam. I have not produced any documents, but it was there in the automobile shop, workshop for 31 days. I have produced IMV report, job card exhibit P7.
Exhibit P1 authorization letter, P2 FIR, P3 complaint, P4 charge sheet, Mahajar, IMV report. What is this job card? What is job card?
Job card, exhibit P7. May I take your lordship's kind attention to job card, on the top right side. Repairs commenced on 2011-2011. Repairs closed on 19/11/2011.
Repair commenced on 2011-2011.
Yes, ma'am. Repairs closed on 19/11/2011.
What is that? 1912?
Yes. 1911.
Commences on 2011, concludes on 1911. How can it be?
I'm sorry, 2010-2011. 2010-2011. Closed on 19/11/2011.
And what is the evidence to show how much is the revenue loss to the corporation?
That there is no evidence.
And then
Your worship, may kindly see, as far as human beings are concerned.
At least when you filed an appeal before the court, you should have placed some document. And why should the court consider all this without any evidence from you?
May I submit, your lordship, may kindly see, ground number E.
No, let us say the bus was in repair for a month. It was for repair, it took 1 month. What is the revenue? What is the loss of revenue? Without the evidence, how can the court ascertain the damages?
I'm just skipping up the ground, for the time being. Now I take your lordship's kind attention to 5E, ground number 5E.
Yes, read.
It is submitted that the tribunal has failed to note that the value of the vehicle which was before the accident will automatically diminish or reduce after the accident. The reduction in value of the vehicle is required to be awarded by the tribunal by
What
way
do
of
you say, Mr.
authorization amount.
Swami, on this?
No evidence is adduced even on this also. The value has come down. No such evidence is adduced by them. And in fact, by getting it repaired, the value must increase substantially. Old vehicle is repaired. New parts are 1,07,000 is granted.
What your lordship may kindly see, the reduction in the value of the vehicle has to be awarded ballot to that extent.
Which year is the vehicle manufacturing year?
Yes, ma'am.
That also there must not be any evidence.
No evidence. No contentions.
Some nominal amount may be awarded, madam.
No, with that exercise this court will not do. Agreed with the order passed in MVC number 1190 of 2012 dated 12th April 2018. The case RTC is before this court. The claim petition is filed claiming compensation of an amount of rupees 4,48,874 at the rate of 12% per annum, interest at the rate of 12% from per annum. The tribunal by order reviewing had granted compensation of an amount of rupees 1,07,340. When counsel appearing for the appellant submits that the court had failed to grant the depreciation, grant the loss of revenue, and also the reduction in the value of the vehicle. And this is on both the counts, the enhancement needs to be enhanced, the compensation needs to be enhanced. Then counsel appearing for the insurance company submits that to say that there is loss of revenue, no evidence is adduced. It is submitted that in fact for an old vehicle, by way of this the court had granted 1,07,340 for the repairs, and as the vehicle, the value of the vehicle in fact would be there cannot be any diminishing of the value of the vehicle. In fact, it would have been enhanced. Expired. Having heard the counsel's when they said there is a material on record. First, on the issue of loss of revenue, the insurance company, the appellant should have placed some material on record either before the trial court or before this court. No evidence is placed before the court. And
Your Lordship's kind submission. One more submission is that, Malad. Your Lordship may see the insurance company has been exonerated for the reason that, Malad, the accident, as of the date of accident, the driver was not holding license. I take your Lordship's kind attention to typed page number 10 of the judgment. Last about 6 lines above.
In the appeal, they have not even contended with regard to this aspect. Exoneration of liability of insurer. It is not
exhibit last Malad, about 5 to 6 lines above from the bottom, page 10 of the judgment.
the driver is not having a valid driving license.
Yes. RW Malad.
So what did the tribunal do?
Offending vehicle driver has no valid driving license. That's what Malad it is contended. Your Lordship, I kindly say the driving license and the same at exhibit part 7 as and as per the said document as on the date of accident. 12/10/2011, the said Muthuras was not pursuing valid driving license. He was having driving license, but as on the date of Malad accident, it
Who
was
is respondent number 1 insurance company?
Yes, respondent number 2.
Insurance company is exonerated following a Supreme Court decision. My lord, this is not even contended in the appeal. They never took up such a contention in the appeal memo also. It is a surprise.
Oh, but otherwise, same whatever is with regard to no license will apply to the second respondent insurance company. He should pay.
My lord, they have not even contended. Insurance company is taken by surprise by making a submission now. The appeal memo also, A to E, my lord. My lord, may kindly.
What
see.
is this, Mr. Nagaraj? You have,
Not even come.
after the order I started dictating, you suddenly understood that the ground should be raised now.
No, it was there, my lord. Among other grounds, my lord, it is there.
For the appellant, you should take all the grounds. The land council appelling for the appellant submits that because the insurance company is exonerated from the liability. Next para. Land council appearing for the insurance company submits that no such ground is taken by the claimant, the appellant, and for the first time this ground is raised before the court. Next in the discussion. Wait, what did you write in the discussion? No evidence is placed before the court either with regard to the diminishing the price of the value of the vehicle or with regard to the loss of revenue. On these two grounds, appeal of the insurance company has to fail. Then coming to the valid driving license, admittedly this court has perused the grounds. No ground is taken. This being a legal ground, this court is inclined to consider the same. And in the light of the law laid down in so and so, still the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle. Accordingly, the appeal of the claimant is partly allowed. Next.
Case number 6. Telecast Gowda for appellant. Gowda BC.
Yes.
This matter relating to applicability of fee and recovery principles to the
Under the Workman Compensation
under the
Act.
Workman Compensation Act. Lords, I am able to allow 2 judgments, but still I think some more research is required.
Yes. Next week,
Now,
this matter on
after 22nd any day. After 22nd.
yes,
Because next week
this
is
matter on 24th.
please.
Yes, next.
Case number 7. Case number 7. Bhanu Prakash VG for petitioner.
For the petition in this
H.
case,
Raj Prabhu.
Respondent. Matter has been pending before the Supreme Court.
This is matter after vacation. Yes, next.
Case
It is
number
submitted
8.
that the matter is pending to the Honorable Supreme Court. Yes, next.
Case number 8.
for respondent
Gunashekar.
number 1,
My lord, I appear on
Girish B.
behalf of
Baldare.
Gunashekar. I apologize for being absent. I also apologize. I also apologize because I would like a short adjournment.
2014, no short date. Let us just see what it is. Who appears for the insurance company?
the insurance company has filed my
Appellant itself insurance company.
Oh, we'll see. What are the grounds? 2014 appeal, we can't wait further. Look at your appeal grounds.
My lord,
Pass over. We will not adjourn it. Pass over. Give the file to him.
Yes.
Yes, next.
Case number 8.
Next.
9. Case number 9.
Yes.
Needful is done, my lord. I have paid the process in the office for the respondent.
2016 appeal. Why you are not done the needful till now?
Actually, Mr. Vijay Kumar had undertaken that he'll file the wakalat, but later on he did not file it.
Then we will. No, we will.
Last occasion, my lord.
Who is the respondent insurance company?
Bajaj Alliance.
Bajaj Alliance.
I already paid the process today in the office.
Okay. HR Renka is directed to take notice in land council for the petty appellant shall serve a copy of the appeal memo on the council.
Already I paid the process also. Today I have paid the process also.
No, it doesn't matter. Ultimately, what you want is somebody should represent. When it is happening, give the papers to her and list this matter. List this matter next week.
Council's name, my lord?
Huh?
Council name to whom I have to.
HR Renka.
HR Renka.
List this matter on 21st. By the time the land council shall proceed with the council for the respondent shall argue the matter.
But
yes.
For orders matter, sale number
Delete
10.
from dismissal.
10.
For the petition in this case, I have taken out the hand summons and served on the counsel who represent the respondent of the trial court.
What is the name?
I served acknowledgement, my lord. And moreover,
the summons sent to court also served on the respondent on 13/8 itself. There's the same
Did you
reflected
get
in the website, my lord, in the postal information. The website it is reflected, my lord.
No, where is that? Have you filed a memo to that effect? No, he says before the court.
I served a hand summons on the counsel for the counsel who represent the respondent before the trial court. I served forensic acknowledgement, my lord.
What is the name of the advocate? When you're filing a memo,
Yes,
memo should contain, as per the order of the court, I have issued hand summons to the counsel so and so appearing before the respondent before the trial court. By signature, how the court will understand what is the name of the advocate. That's what I'm telling all the advocates. That's not the way to file a memo. In the memo should contain who is that advocate, so that we'll record that it is served on so and so advocate. Give it to him, the memo. List this matter tomorrow. Yes, next. Yes. If he will add that name, give it to him.
Name.
Yes, next.
Cell number 11.
I will add the name in the memo.
Yes, please do it. Yes, next. 11.
Cell number 11. Chandaya for petitioner. Chandaya for petitioner. AGA for R4.
No representation for the appellant. List this matter on 11th of August.
Cell number 12.
My lords, for the
MD
appellant, we have to take steps, my lord.
You have taken steps, sir.
We have to. So kindly give a short accommodation.
2012 MFA.
2022.
I appear for R3.
12 MFA double
Apologies,
sounds.
my lord. Apologies. I'm the proxy counsel, the counsel on record. Asked me to.
Who is R1?
The R1.
KSRTC, my lord.
HR Renuka, I think.
2 vehicles involved. KSRTC.
Understand, 1 minute. For service of notice to R1, you are taking time from 2012.
My lord,
We will dismiss your appeal on that ground.
my lord, kindly give a short accommodation. The counsel on record. Yeah.
Already HR Renuka's name is there.
My lord, kindly give a short.
No short. Ask her, pass over this matter. Let Renuka come. We'll decide it today.
Please.
Cell number 13. TN Vishwanath.
Memo is filed for acceptance of paper publication in respect of R2. So and so. Accordingly, the same is accepted and notice to so and so. You send sufficient.
Shivanda.
List in the name of the party. This is matter.
Trial court records may kindly be called because
TCR is already there. List this matter for final hearing on 28th.
Cell number 14.
Admit final hearing. Yes.
Lord, before I could make submissions, I apologize, my lord. I seriously apologize, my lord. The translation not ready. Just can call me in 3-4 days time, my lord. I'll just do it finally, my lord.
What are those? The judgment is in Kannada, in English.
Judgment is in English, my lord.
We'll
Then
deal with it. No translated copies.
the claim is rejected on the ground.
Have this court said that the translated copies
Yes.
should be filed? Give that.
Because its claim is rejected on the ground that delay of 1 month and 4 days, my lords. That's the ground.
Claim has been appreciation of Kannada language documents are necessary.
Finally, post matters on 28/3/20. From how?
No,
from
twice
when
my
it
lord
is
was
on,
pleased to grant me time. Lord, it has been, my lord, given to the my lord translator.
Before this court, it has come up 2 times.
I no concede. That's what I, my lord, I said, or apologized before I could make the submissions. Just grant me 4 days time. Otherwise I'll proceed with the arguments, my lord, if not.
Waste of time.
No, my lord, I apologize for that.
Posting the matters. Next time we will impose.
I'll apologize, my
exemplary
lord. I'll do that.
Matter on 24th of April. By the time if the translated copies are not filed, the exemplary cost will be imposed.
I'll do that.
Yes,
Oblige,
next.
Cell number 15. A. Anumantappa for appellant.
This is also 2015.
Sriram.
Who is R3?
R3.
No representation, this is matter for dismissal tomorrow.
Number 16.
Appearing for the respondent, my lord.
No representation. List is matter for dismissal tomorrow.
Number
Next.
17.
Next memo for acceptance of paper
Akrama.
publication. Same is accepted, a notice to so-and-so is self-sufficient. Next, this is matter on after vacation on 16th of June for file hearing. Admit.
Cell number 18.
DCR is not there. Call for the DCR in this. 17.
Cell
Yes,
number
18.
18. Shekhar LS.
Appellant, pray for 2 weeks accommodation to take out paper publication. Earlier, the notice was dispensed with for the R1. While hearing on admission, the court said that you have to take out notice.
You that?
Cell number 17. It is accepted.
Not 17.
18.
18. Last date, we had taken the steps. Postal share has come that no such person. I may be permitted to take out paper publication.
On what ground the liability is fixed on the owner of the vehicle?
Because there was no valid permit. That was the ground.
Then if there is no valid permit, still the insurance company is liable to pay the company.
Yes, that was the
But that by
submission made.
notice to the
That was
respondent
the
number one now.
Please, it can be
Who
disposed.
appears for the respondent?
Mr. Krishna Swami appears for the respondent.
Where is Mr. Krishna Swami?
Ismail.
Look at the papers. Pass over. Yes,
Cell number
17.
19.
I'm appearing for the 19.
Nagaraj RC.
Which chapter, sir? Who is R3 owner of the
R3 is
vehicle?
the insurance company, my lord. United
Insurance company.
United India Insurance Company, my lord. Already, Dean Vijay Kumar undertake to file wakalat. He did not file the wakalat.
Yes. You said United? United India Insurance Company. Who appears for United India?
I
Yes,
appear
for Shankar Reddy. File. Yeah. Though the court has appointed Mr. Vijay Kumar for R3, till now he has not filed wakalat. As the court is appointing Mr. Shankar Reddy C.
Yes, ma'am.
Mr. C. Shankar Reddy. List this matter. Admit post for final hearing. Call for the TCR. List this matter in the month of July for final hearing. Yes, next.
Cell number 20. Giving us.
Yes, Mr. Vanagada, what is this?
Claim
Who is R3?
R3 is the owner of the
Liability is fixed on?
owner of the vehicle.
On the ground?
On the ground that New India Insurance Company lorry was insured with the New India.
Huh?
Lorry was insured. There are 2 vehicles involved in the accident. Lorry was insured with the New India. That the policy was lapsed. The policy was not valid due to dishonor of check.
What, is it informed to them?
Pardon?
Is it informed to them?
For that, there is no discussion in there.
So in that case, we have to take it that it is not informed. In that case, the insurance company is liable. So why notice to owner now?
Please.
And whatever we can, I think this can be disposed of.
It is.
No representation for the appellant. Post for dismissal tomorrow. Tomorrow we'll discuss.
Cell number 21.
My lord, in this case, M. Venkatesh informed me that Shivanna is filed a wakalat.
Matter may be have tomorrow.
Tomorrow?
Tomorrow, my lord, records necessary, my lord, records. Because dismiss a claim petition.
Admit, post for final hearing. Call for the DCR. Yes, next.
Cell number 22.
Appearing for the
Respondent number 3.
for acceptance.
Appearing for respondent number 1.
So and so, accept notice is held sufficient. Admit, post for final hearing. Call for the DCR.
My lord, we need some time to file the objections for the IA.
IA number 1 of 21. You appear for whom?
Respondent number 1.
Who is respondent number insurance company?
Respondent number 3 is insurance company.
One is?
One is claimant.
Claimant, Farooq Pasha.
Liability fixed on owner, my lord. He is a driver of the vehicle.
Owner of the vehicle.
No.
Owner,
I
owner.
taken paper publication for owner, my lord.
No, no.
Oh, liability fixed on owner, my lord. On
You
the
are owner of the vehicle.
No, my lord. I am
You are the-
claimant, my lord.
Yeah, IA number 1 of 21 is filed to condone the delay of 1089 days in filing the, so it's on condition.
Not in the.
Yes. Admit.
Any date may be,
Hearing.
as on date of permit not,
Tell him.
liability fixed on owner on the condition that as on date there is no permit, my lord.
That also can be disposed of.
And therefore any date may be next week, my lord.
It can be disposed of in the light of the
Pay and
settled law.
recovery as per Amrut Pal case, my lord.
My lord, 1 week time may be given, my lord. We'll file the objections.
Yes, next. 23.
Serial number 23.
Same memo for acceptance of paper publication, accepted
Proceed.
as sufficient. Next.
Delay of
Admit.
1000.
How many days delay?
The same 1089 days.
Same matter,
Ah.
by the same advocate.
Same.
Same delay is unknown on condition. Yes, next.
Admit
24.
final hearing. TCL. Serial number 24.
Give that letter.
My lords, I am for the appellant.
A letter is addressed. Taking extension of time. Is dispose of P and SC number 1150 pending on the file of the to dispose of P and SC number 115 of 2005. And sought for another 6 months time to dispose of the same. Accordingly, this court grants further time of 4 months to dispose of the matter. No further extension will be granted.
My lords, humble submission. There are 2 FIRs filed against the impersonated persons. They have forged the family tree in Bangalore.
Please understand,
Please.
that is nothing to do. The judge has written
No
a
more
letter.
further
I said 4 months.
kindly,
Yes.
my lords.
Yes, next.
Obliged.
Serial number 26. 25. Serial number 25.
Oh, yeah.
Adnav B.
Who is
Bangawadi.
R2?
My lords, it's showing that the notice has been served.
Where is it?
We've received the online acknowledgement from the website.
File memo. It is stated that notice to R2 is already delivered and they'll file a memo to that effect. This is matter on 21st. Yes, next.
Serial number hearing on interlocutor application. Serial number 26.
Any stay is granted in this, not granted. And by the next date of hearing, learned counsel for the appellant shall file before this court the status of the case before the proceedings of the trial court. The entire sheet produced after remand. Yes, next.
Serial number 26 adjourned. Serial number 27 adjourned. 28. 27.
27, my lord, I sought for paper publication to the
Same, I have 1 of 25.
Sahitya Karnataka Udupi edition.
Tell him the dates. He should listen to what the dates.
Sir, draft on or before 21 4, sir, for draft and hearing date is on 3/6.
On or before?
21 4.
Please.
Yes, next.
Cell number 28.
For the respondent, my lord.
I
Yet to
number
serve copy on me, my lord.
1 of 18 is filed to condone the delay of 282 days in appeal. Same for the reasons stated on condition. Then counsel of the appellant shall serve the copy of the appeal memo on the counsel for the insurance company. Admit post of final hearing. Call for the DCR.
Wait.
Next 29.
29. Girish B. Baldare.
I appear for R1.
Appear for the appellant, madam. The IA number 3 is a file including the appellant number 2 is a Kaveri Neeravari Nigam. Kindly
Same matter.
Same order.
IA number 3 of 23 is filed to implead the the beneficiary as a proposed respondent number 2. Number 2. In the similar matters, already the proposed respondent Neela, what is that?
Kaveri
Kaveri Neelavari Nigam is already impleted and the matters are remanded. Accordingly, Mr. B.R. Prashant take notice on behalf of the respondents, considering the fact that the beneficiary is not made a party. I number 3 of 23 is allowed, and the counsel for the appellant shall make the necessary amendment to the cost title within 2 days.
Yes, Mr.
Next, the IA number 2 of 20, IA number 1 of 23 is filed to condone the delay of 842 days. That is on. Then IA number 2 of 23 is filed protection of the additional documents. This the appropriate application can be moved before the trial court. As such, no further orders needs to be passed on IA number 2 of 23. Next no, it's an order on the main MSA, same like in the earlier cases. Yes, next.
Please, Your Lordship.
Serial number for admission, serial number 30.
It's a transfer
Yes.
petition.
From where to where?
From Kunigal to Bangalore.
Kunigal to Bangalore.
Bangalore.
How much is the distance?
From Kunigal to Bangalore is 80 kilometers. 80 kilometers.
Hmm.
The
What is
both,
pending here?
my lord, he has filed a petition before the Kunigal court for restitution of conjugal right.
Hmm.
Petitioner and respondents are the permanent residents of Bangalore. Their marriage took place in the Bangalore itself. Even now they are residing, all the documents shows that they are residents of Bangalore.
Why did you file a case at Kunigal?
Only
My lord,
now.
I'm practicing as agriculturist, my lord. I'm residing in Kunigal only, my lord. Hence I have filed. My lord.
Where is your petition? Restitution petition?
My lord, annexure, my lord, G, my lord. Page number 52, my lord. 56, my lord.
Children? Any children in the wedlock?
Yes, my lord. One female.
And your lots of abnormal child, one child is there. It is under the control, maintenance of the petitioner. Your lordship may kindly see the petition, page number 73 of the petition. He has filed a private complaint against this petitioner and his parents. What is the address he has given? Your lordship may kindly see.
N. Vasant Kumar, Bangalore.
Bangalore.
Respondent
Only
brother
for
has
the
been
purpose
filed.
of harassing.
Respondent has not filed PCR, my lord.
PCR is N. Vasant Kumar is who?
He is my brother, my lord.
He is staying here.
Yes, my lord.
You are staying there.
Yes, my lord.
Please come. Agreed. The present petition is filed seeking transfer of MC number 1997 of 2022 pending on the file of the senior civil judge at JMFC Kunigal to Bangalore. The learned senior counsel appearing for the petitioner wife submits that the marriage had taken place on 6/2/2014 and they are blessed with a girl child on 22/2/2018 who is differently able.
Child.
The girl.
Girl child.
My lord, for which, my lord, they have not placed any document, my lord, to show that that child is
Can
disabled.
anybody say that the girl is special child? Is it the girl is a special child who requires special attention and the mother is taking care of the child after the disputes arose between the parties. On 12/12/2022, the husband has filed a petition before the principal senior civil judge Kunigal. That's MC number 97 of 2022. And the wife had filed a petition under 125 CRPC seeking maintenance, that is criminal miscellaneous number 213 of 2022 on the file of the family court at Bangalore. And she has also filed a petition, the Domestic Violence Act, under the provisions of the Domestic Violence Act for the 3rd MMCC Bangalore, that is criminal miscellaneous number 47 of 2023. And senior counsel submits that the distance between both the bases is about 80 kilometers. And when both the parties are residing in Bangalore, only to harass the wife, the petition has been filed at Kunigal, and the same needs to be transferred considering the inconvenience caused to the wife. Next para. When counsel appearing for the respondent husband submits that though earlier he was staying in Bangalore, now he is doing his agriculture and residing in at Kunigal. As such, the petition.
Producing photographs, my lord.
Agriculture, that to show that you are agriculturist. That he is doing agriculture there, and as such, it's difficult for him to, if the matter is transferred from Kunigal to Bangalore, it is submitted that no document is placed to show that the child is a special child. Next para. Having heard the counsels, so and so. The wife is as per, it is an unbeaten fact. Earlier, the marriage had taken place at Bangalore. Both of them stayed together at Bangalore. And even the brother of the respondent has given a complaint, a private complaint against the parents and against the wife also.
Yes, ma'am.
Against the petitioner and the parents, and showing his address at Bangalore. According to the husband, earlier he was in Bangalore, but now he is doing agriculture and he went to Kunigal. Even assuming the same, that he is staying at Kunigal, there are two cases under the Domestic Violence Act and also the petition seeking maintenance are pending at the courts at Bangalore. The respondent Karen has to come to Bangalore to attend those cases, and that apart, considering the distance of 80 kilometers and she has to take care of the special child, this court deems it appropriate to allow the petition. Accordingly, so and so is withdrawn and transferred. Yes, next.
Till number 31, reject HV for petitioner VB Shivakumar.
Yes.
In fact, the parties have filed a 13B petition before the trial court.
So we'll record that in the light of the same, nothing.
I'll file a memo also with the document.
Is then counsel appearing for the respondent take that?
Madam.
Has filed a memo before this court stating that already the parties have settled the dispute and a petition under section 13B of the Hindu Marriage Act is filed before the court at
Mysore.
The principal family court at Mysore, and hence no further is filed, considering the fact that already a petition is filed seeking under section 13B. No further orders needs to be passed in this petition. Accordingly, the petition is closed. Disposed.
Till number 32.
Yes.
32. VB
Counsel for the
Sidramaya.
respondent is present. No representation for the appellant is. Yes.
Can you pass over, madam?
What passover? What is this you appear for?
Respondent, madam. And another
Respondent?
respondent number 1.
Wife, husband, who is he?
No.
It is a suit transfer.
Yes, ma'am.
Seeking transfer of suit.
Yes, ma'am.
Top passover. Yes, next.
Till number 33.
Before the petition in this case.
Yes.
Because the
SV Prakash.
wife is residing at Koramangala and she has filed a DV case before the Honorable Fourth
Counsel for the
MMC.
appellant is, counsel for the petitioner is present. No representation for the respondent. This is matter tomorrow as part of.
Please.
Yes, next.
Till number 34. Till number 34.
Same order in this appellant, no.
My lord.
No representation, respondent is present. This is matter as part of tomorrow.
My lord, sir, I need some documents, kindly have it. I also filing of objection, kindly have it after occasion.
When did you file your wakalat?
I filed, only thing is the employment, regarding your employment at Bangalore, I may get it within a few days, my lords. That is, because I want to
Let's
establish.
just stay in their favor.
Stay in their favor, I will get the documents so that I can.
Request of learned counsel for the respondents 34. List this matter after vacation. And the interim order earlier granted is extended till the next date of hearing.
Please.
Yes, next. Yes.
For petitioner wife, my lordship.
Counsel for the petition is present, no representation for the respondent. This list is part of. Next 36 tomorrow.
Till number 36.
Yes, 36.
N. Manjunath.
Agree for objection along with the documents. Petitioner in this case, Lord.
Yes.
Lord,
Along with
the place of marriage is at Chikbalapura. The permanent address of the.
You're filing objections. Yes. Have you served a copy on them?
No, I'm.
Serve him. Serve him and file the section.
Produce.
The land counsel for the petition. Respondent submits that he's filing objections. He shall file the same before the registry. List this matter on 23rd.
Till number
20
36.
PA may be extended. 3rd
April.
PA may be extended.
What is that?
PI, temporary injunction.
That is
Interim
Interim
order
order,
earlier granted is
sorry.
extended
25th.
till the next date of hearing. Take it on 26th. List is marked on 25th.
Obliged, my lord.
Yes.
Serial number 37.
Please, my lord. My lord, wife filed the seeking for the transfer to.
I may be
Bengaluru
permitted to file objections, my lords.
When did you file your wakalat?
On 2nd of April.
At the request of learned counsel, the respondent for filing objections. List this matter after vacation will post it. List this matter on 17th of June. Interim order earlier granted is extended till then.
Please.
Serial number 38. Pramod R for petitioner.
Yes.
38. Pramod R.
Representation for dismissal tomorrow.
Serial number 39.
I'm appearing for the appellant, my lord. Judgments are in Kannada, my lord.
It's submitted that the judgment is in Kannada. This is matter on in the month of June for final hearing. Admit post for final hearing. TCR is there.
TCR is.
Call for the DCR.
Yes. Serial number
Final hearing
40.
in the month of August. Yes. The 40.
40.
Much of.
Admit post for final hearing. Call for the TCR.
Serial number 41.
I appear for one, your lordship.
No representation for the appellant. This is matter in the month of August.
Serial number 42.
Appear for appellant, my lord. Actually, argument counsel is keeping now. Well, please give me a short accommodation.
This is matter after vacation
Serial number
published
40.
on 10th of June.
Serial number 43.
Appear for respondent, my lord.
Vijay Kumar.
MSA of 2024. Translated copies of evidence of PW1, DW1 and PW2.
Filing, my lord. Translation copies, my lord.
Yes.
Copy in art, sir.
Yes, we'll give a date, give him. Let him also look at
Yes,
it.
my lord.
This is matters on 23rd.
23rd.
Yes.
For interim
Learned
order.
counsel has already filed the translated copies. You look at it, interim order is there, extended till
Yes,
that day. Yes, next.
Serial number
Grateful.
44 for final hearing RB Sadashiwappa. For appellant M. Arun Ponnappa. 44.
No representation on behalf of either of the parties. List this matter for dismissal tomorrow.
Serial number 45. 45. Krishnamurthy D for petition appellant. Dheeraj Kumar.
For dismissal.
Serial number 46.
For dismissal, they are on all these matters for dismissal, whoever are not there on 22nd.
22nd.
Yes.
22nd.
40.
Serial number 46. Venkataya Gowda K.
Same, no representation on behalf of both the sides.
22nd. Serial number 47. Pradeep B. CR
Corresponding is
Subramania.
kindly pass over, my lord. Challenging liability, my lord, on the ground of the
Ground.
permit violation, my lord. As on date of there is no pain recovery, my lord.
I request for a pass over, my lord. Counsel is on way. I'm not in the record.
No. You're the claimant. Whom you're representing.
My lord, I'm sorry, my lord. The party has said that, my lord, his advocate is on way. He requested me. The party is there, my lord. He requested me to take pass over.
Is he the claimant or the owner of the vehicle that you asked him? If he is claimant,
Claimant, my lord.
he is not losing anything.
Yes, my lord.
Pay and recover. So no passover is required. Give the file.
Case of death, my lord. Date of accident.
The present petition is, the appeal is filed, agreed with the orders passed in MEC number 37 of 2012 dated 26 November 2016 by the insurance company. The insurance company has filed this appeal, agreed with the order passed in MEC number 30, award passed in MEC number 37 of 2012 dated 26 November 2016. The claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the death of the deceased. There is any corrected appeal?
Oh, my lord.
It's not there. Agreed by it is a case of the claimant that on 25/7/2011 at 3 p.m. the deceased was riding the motorcycle and is going to Tarn water supply office. At the time, one auto came. One auto dashed against a motorcycle in a rash and negligent manner with high speed as a result of which the motorcycle rider fell down from the motorcycle and sustained severe head injuries. While shifting him to the hospital, he has succumbed to the injuries. The court had granted compensation of an amount of rupees
9,82,000.
9,80,000. When it comes to the liability, the court, where is the observation on liability?
That's para number, judgment para number 22, my lord. Para number 19, issue number 4.
19.
Judgment page number 24, my lord. Bottom of the line number 5. Admitted that created the exhibit R5. Further, he has admitted that the permit a said vehicle could be applied within jurisdiction of BBMP. The evidence of PW to disclose that at the time of the permanent registration, they asked insurance to permit proceedings further the chief examination itself. The such scratch admitted that K05AC.
So, what do you say? What is that? What is the finding of the court?
Deviation of permit, my lord. This is
And read. Court has not accepted that.
that one we are challenging.
No. Does it come to page 24? From bottom.
Please, my lord.
According to RW2 immediately after the accident has obtained transfer permit on 13/5/2011. Read
Please.
that.
13/5/2011. That permit has been renewed on the year of 2012. According to the permit is collusion with the third respondent insurance company. The second respondent has created exhibit R5 only for the purpose of giving trouble to the petitioner in collusion with the RW2 insurance company has created exhibit R5. Further, he has admitted that there is permit the said vehicle could be applied within jurisdiction of BBMP evidence. RW2 disclosed that the time of the permit registration, they asked insurance and permit proceedings further the chief examination itself. At that one stage, he has admitted K05AC 5297 has been registered 18/3/2011, and another stage he says that there was no court to give a permit to the new auto if so out the registered new auto without permit or permit.
Ask Pradeep to come.
Please, mother.
Ask her.
Number 48.
For respondent number 1 and
Judges. For appellant.
respondent number 1 and 2 in this case, my lord.
Vijay Kumar ND.
Is on what ground the insurance company is before the court?
My lord, before the contributor negligence was by the two lorry drivers, my lord. Next, my lord, para number 10 of the judgment, my lord, which says that, my lord, there is a both the negligence are there, my lord.
Come, Mr. Lingaraj, to the court today.
H.S. Lingaraj.
Have you seen him?
I have not seen him, my lord, today.
Yes, Mr. Pradeep. Inform Mr. Lingaraj to come. Yes, if they come, I'll take it right
Please,
now.
Lord.
Pradeep is there, ask him to come, we'll complete that case. Inform him. Yes, next.
Cell number 49. Cell number 49.
Yes, Professor.
Ranjana Iyer.
My lord, I appeal for the petitioner. I request a pass over, my lord. Seniors on his legs, my lord.
Passover, there is no Lokatalat matters are there. This is matter after vacation, 49.
My lord, date may be fixed before vacation.
This is matter on 9th of June. Yes, next. Next. Where is the next list? No, there is another Lokadalat matters are there. 2:30 they said. Anybody ready in the passwords?
Serial number
18, my lord.
Both parties.
Yes, my lord.
Serial number 18 was passed over.
Other side should be there. You are there.
Yes, my lord. The reason is the notice was served for the R1. He's the owner of the auto rickshaw, and the return is no such person. The return remark is no such person. So they need to take paper publication, my lord.
Then they are ready for.
Because insurance company is exonerated in MACT.
Let's this matter on 22nd of April. By that time, if the substituted service of notice is not filed, the appeal against the owner of the vehicle will be dismissed.
Please.
Yes.
Much obliged, my lord.
Any other matter where both of you are ready?
My lord, we are both here.
My lord, serial number 9, my lord.
Yes.
Number 8. My lord, I had actually argued this matter earlier, but not before your lordship. The basic ground is that we say that the accident did not take place because the material on record leads to very, very serious doubts. The material produced by them, material produced by us shows clear contradictions. The discharge summary, the discharge slip itself, the MLC,
Let's look at it.
the complaint.
Let's read that particular portion of the order. Paragraph number of the judgment.
My lord, I'll just point out to the, okay. The judgment per se ignores those things, but
Let's
material.
read from 9, para number 9 about your case, your officer.
One Sri HP Devendra Kumar, who is a development of the Oriental Insurance Company Limited, Hassan, got himself examined as, that would be not PW2, my lord, on behalf of the second respondent. He has also furnished 4 documents which are respectively marked as exhibits R1 to R4. I have heard the arguments on petitioner's side. Second respondent furnished written arguments, meticulously perused the records. PW1, being the petitioner, has filed affidavit by way of evidence stating that on 17/9/07 at 2:30 p.m. when he was standing in front of so and so, a vehicle bearing registration number so and so, the rash, negligent manner, etc., etc. He was immediately shifted to Mangala Hospital, Hassan. Now, this, my lord, is relevant because the MLC shows that he was first shifted to Sri Rajendra Hospital.
So we'll see, please read.
There he took treatment as an inpatient for 2 months, and even now he is taking treatment as an outpatient. According to him, he has spent more than 50,000 towards medical expenses. Second respondent filed written argument stating that the alleged accident has taken place on 17/9/7 at 2:30, but there is inordinate delay in filing the complaint. Because the said complaint has been lodged before the police on 1/10, there is a delay of 14 days in lodging the complaint, which has not been properly explained by the petitioner. Further contended that also pertinent to note that the alleged complaint was not lodged by the petitioner. It is the first respondent, Dr. Srinivas, who is none other than the owner of the vehicle, who has lodged the complaint. The submission made by the learned counsel for second respondent is not correct one.
So first of all, let's go to the exhibits.
My
What are the exhibits marked?
The complaint, my lord, is.
Let's forget about the complaint and the delay. Medical documents.
Yes.
So
Kindly see exhibit P6. Sorry, P12, which is the discharge summary.
No, where that MLC is not MLC extract.
MLC
Exhibit
we have
R3.
produced. We have produced.
So
the
exhibit
MLC.
R3. What is that set to have by
Which is
off at 3 p.m.
This is issued by Sri Ramarajendra Hospital.
No, wherever he has been to the hospital, there is a there, whether which hospital it is.
The contradiction is there. He is said to have gone before the accident took place at 2 o'clock to the Mangala Hospital at Hassan. He does not anywhere mention,
No, they say that the accident is at 2:30.
yes,
No.
but the discharge summary says it was at 2
Oh, that
o'clock.
is
he
the,
went-
those kind of typographical. This is the
Very
first document.
That is okay.
First document.
But he does not mention that he went to Rajendra Hospital at all.
In that case, you should have examined somebody.
I have examined.
Whom you have examined?
Exhibit R3 is marked by me.
Correct. So how are you denying exhibit R3?
I'm not denying it.
So, and
I'm
what
saying-
is, how it is not, like supporting the case of the claimant?
My lord, the claimant says I went straight to Mangala Hospital.
This is which hospital?
This is a different hospital. It is Sri Chamarajendra Hospital. There are several such contradictions in his evidence. He says,
No, let's say he has gone to Chamraja Hospital.
yes,
Even in that case also, it strengthens his case that he had sustained injuries.
my lord, he couldn't be in two hospitals at the same time.
Hmm.
And then again, the other contradictions would be when he was in the
How
hospital.
come you know that he went to this hospital?
We check. We
So even as per that, there are injuries.
My lord, the question is, was it this car which was involved? Because Dr.
That is a
Srinivas-
different aspect. That has to be decided that is now whether he had sustained injuries or not in the first place, either that MLC or this MLC, you yourself, you say that
My
we
lord,
have
it is some-
investigated.
Yes. The question is, which vehicle did he meet with?
That the MLC will not tell.
Correct.
He has injury, he has sustained injuries.
Now-
Now to say that a particular vehicle is not involved, to say that it is involved, what is his evidence? To say it is not involved, what is your evidence?
Yes.
So now as far as accident is concerned, MLC supports his case that at 3 o'clock he had sustained injuries. Then what are the next documents?
Now,
Now, what is the reason for the delay in giving the FIR? What was it, what the FIR says with regard to the delay?
my lord, the complaint is not given by the petitioner at all. It is given by Dr. Srinivas.
Doctor?
Srinivas.
Who is the doctor?
He is the respondent, said to be the owner of the vehicle. The driver is said to be his uncle. And there is a Dr. Srinivas who has treated him, who has made a reference from Mangala Hospital. The whole thing, therefore,
So that vehicle belongs to whom?
that vehicle belongs to Dr. Srinivas.
Which vehicle? Offending vehicle.
The vehicle which is said to be the offending vehicle by Dr. Srinivas.
And very
But-
same doctor treats him.
Yes. Yes.
It is
Therefore, it
stated that,
leads to
my
the
lords,
suspicion that he is trying to-
he referred for scanning, that is what it says, my lords. He referred some scanning. It is
Yes.
not there, my lords, like only stranger to treat, my lords.
Look at the documents. Appears
My
to
lords,
be
in
some-
IMV report also, my lords, it is
appears to be fishy. We will see. You can also look at the documents. Looking at the documents, you have to submit
please, my lords.
tomorrow.
Please, my lords.
Tomorrow. Yes, next.
My lords,
Tomorrow is inconvenience to.
Huh?
Tomorrow is inconvenience.
To whom you appear?
For R2 minutes.
R2 is who?
Dr.
Is owner of the vehicle.
Dr. Srinivas.
Please.
We will hear it. Yes, tomorrow.
Yes.
Next.
Next Passover. Serial number 12, Passover. The Ravisha.
Call the passovers once.
Yes, ma'am. Passover matters. List number 1, 8 urgent. Serial number 12, Ravisha.
My lord, in this
Oh,
case, I
Mahesh.
was directed to take notice for corporation. My lord, it has been stated that I had not filed for wakalat. My lord, I'm so sorry. I'll have it filed within 1 week.
D. Vijay.
Yes. Yes.
Hakidara? D. Vijay Kumar Hakidara?
It is already, it is adjourned where I asked her to take notice.
Yes, my lord. My lord, I had not filed wakalat. I'll file, my lord.
Yes.
One more.
What is that?
I think second list serial number 2.
Don't matter Passover. ಯಾವ್ದು? Huh?
No, in one more matter, I've asked her to.
Serial number 12 on the Passover.
I'm responding.
No, if you're ready with the case, this is a 2012 matter. You can file wakalat after the
Yes,
order
ma'am.
is passed
Yes, ma'am.
also.
Yes, ma'am.
What is this matter about?
My lord,
You don't have the file?
my lord, I'll just, I
Take, you had the file.
simultaneously I can,
You had
can
the-
can I
you had
see the LCR, my lord? From LCR, I just require the judgment, my lord. Appeal, my lord.
Mr. Mahesh,
ಅಷ್ಟೊತ್ತಿಗೆ order sheet ಅಲ್ಲಿ
who is contesting in,
order sheet ಅಲ್ಲಿ
serial
ನಾವು
number 12?
settlement ಮಾಡಿದೀವಿ.
You are contesting or Renuka is contesting respondent? Serial number 12.
Which list, madam?
List number
My
one,
lord,
serial number 12.
50-50, my lord. We have been, both of us have been,
Contributory.
page 25, my lord, respondent, both KSRTC and respondent number 3 shall deposit the compensation in the ratio of 50% each.
Yes, give that.
Well, a case of injury, my lord, parat.
No, not lower, only the.
My lord, I'll take the, my lord, LCR is,
Not the LCR. Give me that file.
MBC 3011. ನಂಗೆ ಇದು TCR ಕೊಟ್ಬಿಡಿ ಸಾಕು.
One ground is with regard to the disability.
Yes, my lord. 7%.
Then they are seeking the attendance charges, 30 days inpatient.
Lord, this is in respect of 3011, my lord. 3011, this appeal, my lord, is.
Yes, yes.
Para 15, my lord.
3011.
Yes, my lord. Para 15.
No, no, I'm just looking because the council is not there.
Para 15.
They're on the income, they're on the disability.
Or your lordship could see, my lord, entire, without their grounds, my lord, whatever
No, no. Because they are not there, why they are seeking enhancement, we have to see.
But para 15, my lord.
Please read.
1.5. Fracture of tibia, type 2, crushed lacerated wound over the right ankle, swelling, deformity of the right ankle, and injuries all over the body.
23 to more than 1 month he was there
Yes,
in
my lord.
hospital.
More than 1 month, my lord. And the disability, my lord, is
Suspected disability of 14% to the whole body.
I think the doctor has taken 7%.
No, 14% to the whole body.
Yes, my lord.
Taking into that, lesion and sustained fractures
Yes.
also.
14%.
Must have suffered lot of pain and agony. So now under the pain and agony, there is one fracture or two fractures.
My lord, crush injury also is there, my lord. Type 2, my lord, what I read is
Will grant 60,000.
type 2 fracture of tibia, my lord, and crush lacerated wound above the right ankle.
Pain and agony 60,000. Then medical expenses.
But, I think, my lord, 2008 accident, my lord.
50. Medical expenses.
Yes, medical expenses is 15,000, my lord. 1.5.
1.5.
Yes, ma'am.
Then
loss of earning, my lord.
which year is this? 2008,
my lord, accident. He
should have
says
been-
he was working as a painter.
Court taken 4,000. It should have been 4,500. 4,000. So loss of income during laid up period. We'll take 3 months. 3 into 4,500. 15,500.
But there's only one aspect, if your lordship could see, my lord. What the tribunal says is in paragraph in page 14, my lord, the last 4 lines, the tribunal comes to the conclusion that the assessment is done after lapse of 3 years, my lord. That's one of the reasons.
Whatever is his condition as on that day should have been. It doesn't matter. No, it will.
Probably the reason is.
If at all, it would have improved after that. If it is there at 14% at that point of time.
Since both of us are sharing, my lord.
So loss of future income. So we are taking 4,500 into 12 into what is the multiplier?
That was,
his age is His age was, as on that 3011, 20 years.
18.
18 multiplier into 18 into 14 by 100. Well, into 18 into 14 divided by 100. It comes to 1,36,080. Then nourishment, attendant, transport, 30,000. Then loss of amenities, to 20,000. Small, 30,000. That's it.
With your lordship's leave, my lord,
Huh?
I appear, my lord, for the
Huh.
Bajaj Insurance Company, insurer of the motorcycle. I invite your lordship attention to, my lord, typed page 7, para 9 of the judgment, the issues framed. Whether the petitioner proves that he sustained grievous injury in road traffic accident occurred on 23/2/2008 at about 8 a.m. near Choudahulli Cross, so and so, driving off, negligent driving off the bus bearing number so and so. Then, my lord, now you will have to kindly turn to, my lord, typed page 11. The finding, my lord, the issue on this issue, we 3 lines from the top, my lord, PW 11, my lord, PW 1 and 2 content that it is due to the negligence of the KSRTC bus. The oral evidence of PW 1 and 2 is corroborated by exhibit P1 to P6 and 9. As such, it is held that both petitioners have sustained injury.
Now, either of you have not filed any appeal. So as far as that negligence aspect is concerned, we are not going. We are only on compensation enhancement.
Lord, before that, my lord, I would like to invite your lordship attention to, my lord, page 25, the operative portion of the order. There is a mistake that has to be distinct.
Yes.
The respondent number 1 to 3.
You're reading where?
Page
Type
25.
page 25, my lord, operative portion. Respondent 1 to 3 are jointly and severally liable to pay the compensation as awarded by the tribunal. But the respondent number 1, KSRTC, and respondent number 3, insurance company, shall deposit the compensation amount in ratio of 50% each, and the same shall be paid or deposited within a period of 30 days. This goes contrary to, my lord, the finding on issue number 1.
Let's check that, my lord.
Yes, that I'll record. Please come.
That has to be, my lord, thing, and Bajaj, my lord, has to be exonerated by the mistake, my lord, in the operative portion.
Agreed with the orders passed on MBC number 3011 dated 15 September 2011. The insurance company, the claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 4 lakhs for the injuries sustained by the claimant in the road traffic accident. The tribunal on the issue of the liability, on the issue of negligence, has held that
Type it page 11.
Now the court says
Yes, ma'am.
both the petitioners have sustained injuries due to an actionable negligence of the driver of the KSRTC bus.
Bus.
Accordingly, the issue is answered.
Yes.
Now, where is the occasion to fix the liability on the insurance company?
Since the same is not questioned,
It's
my
a
lord,
mistake, my lord, in the operative portion.
they should have filed an appeal, my lord, and they cannot get it corrected. At least
No.
prosecution should have been filed.
Using
Nothing
the
is
appellate
done.
power, the court can do it.
My lord, if they have not, my lord, the thing is, my lord, there is nothing on record, my lord, to.
It's a typographical mistake, it appears to be, because when the court, there is no finding with regard to the composite negligence. On the negligence aspect, it is only fastened on you. Then how come, why should the insurance company pay?
My lord, if your lordship could see para 27, my lord.
Let's read that.
So far as liability is concerned, respondent number 1 has
that we will see now.
contended
20?
in the written statement.
No,
that
no,
case
27, read.
Yes, ma'am. So far as liability is concerned, respondent number 1, that is KSRTC, has contended in the written statement in para 9 that KSRTC is not the owner of the bus bearing number so and so. The said bus is hired on contract. The contract was executed on 3rd day of so and so, and as per clause 9 of the contract, the KSRTC shall not be liable for any claim arising out of any
Your
accident.
KSRTC bus is insured by the
Yes,
insurance
my lord.
company.
My lord, if it is so, my lord, that I need not have to pay anything, my lord. That's the reason without filing work on it. I'll just read, my lord. Then I'll just continue, my lord. Then in connection with the injuries or loss of life sustained by the passenger, the owner of the bus was one Ramana Reddy, son of so and so. As such, the first respondent is not liable to pay the compensation. On the other hand,
In that case, insurance KSRTC need not pay the money.
at all, my lord, it is the insurance company, my lord. I'm grateful to Mr. Ram. I think if they have filed an appeal, my lord, usually, my lord, what happens, the same counsel would be given,
It's
my lord.
settled law.
Yes, my
If
lord.
the KSRTC bus is
Kulsum
insured.
case, my lord. UPSRTC versus Kulsum
UPSRTC
case.
versus?
Kulsum, my lord.
Kulsum.
Kulsum case. It's the higher, my lord. It's the
Number
insurance.
1 cannot run contrary to your.
No. It is not contrary, Mr. Mahesh. Now it is. Now the court said the insurance company, the KSRTC vehicle is at fault. KSRTC vehicle is insured by you. So, in the light of the law laid down in that UPSRTC's case, you are liable or the KSRTC.
But what is finding? Definite finding of issue number 1.
Correct.
You
There
are
is nothing.
Yes,
KSRTC liability. KSRTC bus is involved in the accident. That is insured by you. You will pay it.
But it's not KSRTC. I am not the owner, my lord. I'm only, my lord, lent my name.
Yes.
It's the
But
entire.
I am inviting, my lord, the finding of the tribunal on issue number 1 at typed page 11.
I will record the very same submission of yours and Renuka, and the submission that in an appeal, the court, when a mistake is on the face of it, that can be corrected by the court.
That's what
Yes,
my submission is.
That's held that the accident has happened because of the actionable negligence of the driver of the KSRTC bus. When it comes to the liability, the court had discussed at paragraph number 27 that the bus KSRTC is not the owner of the bus, and the owner of the bus is one M. Ramana Reddy.
Well, it is a hired bus. It was a hired bus, but the ruling of our High Court cannot do that.
Respondent number 3 insurance company had insured the said bus, which was given on hire to the to the KSRTC. Bus was in custody of the KSRTC as on the date of the accident. The court, the tribunal gives a finding that the respondent number 1 has not led any oral evidence to prove the defense taken in the written statement. Even the insurance company has also not produced any material to show that KSRTC is liable to pay the compensation. Admittedly, both the claimants are third parties to the insurance. So far as liability of the respondent number 1 and 3 in case of agreement between the KSRTC and the owner of the vehicle is concerned, and relied on the judgment of the case Rajasthan State Road Transport Corporation versus Kailashnath Rewat at Kotari, reported in 1997, 7 ACC 481, The court held that the KSRTC alone is liable to pay the compensation. Then the court had also referred to the subsequent decision in United India Insurance Company versus Santro Devi and others, 2009 1 ACC 558. And also another judgment versus in Divisional Management National Insurance Company Limited versus S. Sunil Kumar and others, decided on 14/1/2011 by the Karnataka High Court. The court held that both the insurance company as well as the KSRTC are liable to pay the compensation, which is apportioned at 50% on both of them. 50% each on them. Land counsel appearing for the insurance company submits that when the finding of the court at issue number 1 is with regard to that the KSRTC bus is liable to pay for accident has happened because of the rash and negligent driving of the driver of the KSRTC bus. In that case, the tribunal, when it comes to the liability, ought not to have held that both the KSRTC and the insurance company are liable to pay the compensation at 50% each. Land counsel appearing for the KSRTC submits that though it submits that in the light of the law laid down in UPSRTC versus Kusum, what is that? Kumsum.
Yes.
Reported in so and so, give the citation.
Yes.
Reported in so and so. When the particular vehicle is on hire with the APSRTC and it is insured with the insurance company, in those cases, insurance company is liable to pay the compensation. Land counsel appearing for the KSRTC submits that though the KSRTC has not preferred any appeal, the said finding of the court is contrary to law. Next paragraph. Land counsel appearing for the claimant submits that the compensation that is awarded is not just and reasonable for the pain and agony for the transport and on the other heads, if the amount granted is not reasonable for the interest is awarded at 6% is also on the lower side. It is submitted that 14% disability was not considered and no amount is granted for the future loss of earning. Next slide. Having heard the counsel so and so. First, coming to the contention of the insurance company and the KSRTC, both of them submits that though the appeal is not preferred by them, still this court exercising the appellate jurisdiction can consider when the judgment of the court on the face of it is erroneous. According to the land counsel for the insurance company, when the court gives a finding that the fault is on behalf of the KSRTC, insurance company is not liable. The counsel appearing for the KSRTC submits that when the vehicle is hired by the KSRTC and it is insured with the insurance company, in the light of the settled law, in case of that is there in our judgments, in our list of judgments, it is there. In the light of the settled law in UPSRTC versus Consum, still the insurance company is liable to pay the compensation. This court has perused the order of the court. There is no dispute that the accident has happened because of the negligence on the part of the driver of the KSRTC. And admittedly, as per the material placed before the court and as per the observation of the court, it is stated that the vehicle is on hire with the KSRTC and the said vehicle is insured by the insurance company. In that view of the matter, in the light of the law laid down by the honorable expert in so and so, for the compensation amount, the insurance company alone is liable to pay the compensation. Next paragraph. Coming to the enhancement of the compensation, the claimant had sustained the pain, swelling and deformity of the right ankle, and there is a crush injury. Considering that, under the head of pain and suffering, this code is 950,000. towards medical expenses, trial court had granted 15,000. No, the trial court has granted as per the table given below, that table you extract. The, coming to the loss of income during the later period, according to the claimant, is earning 6,000 per month. And this accident had happened in the year 2008, and there was no, no evidence placed before the court. Considering the charge prepared by the legal services authority, this code is taking 4,500. It comes to 15,500. Then coming to the disability, doctor had said that is 14% disability to the whole body, but the court holds that the it is assessed after 3 years. What is the disability as on that day has to be considered by the court, and considering the 14% disability and 4,500 as salary into 12 into 18 into 14 by 100 is 1,66,080 at the rate of loss of future income. Coming to the nourishment and attendant and transport, as the estate beyond 30 days as inpatient, this code is granting 30,000. Considering the disability of 14% loss of amenities, this code is granting an amount of rupees 30,000. Towards legal expenses in the light of the law laid on in Mekala versus so and so, 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of 2,86,580, which the third respondent insurance company is liable to pay. The interest is 6%.
I think Mr. Mahesh has not seen. The client have deposited 50%. The other 50 we have not deposited, my lord. That's why I'm checking whether we have filed an appeal. Because usually we file appeal in such cases, my lord. Because he said that I have to pay the entire thing.
Come back in the afternoon, and if at all,
if it is there, my lord, I'll
tell you. Otherwise, the same thing
yes,
we'll make
yes,
that.
Yes.
Yes, next. Any matter where both the councils are ready? In the past over matters?
There's one in the second list, my lord. Serial number 2, my lord. Only quantum, my lord.
Who appears? Serial number?
Number 2.
List number 2.
Oh, that's all referred to Lokada. Yes, next.
Passed over matter, serial number 32.
And I am for the appellant in the another petitioner.
Let it come in the afternoon. Please come. Yes.
Serial number 48, seeking an adjournment, my lord. Serial number 48, seeking an adjournment, my lord. Senior is not.
Which year is the matter?
2017, my lord.
17. Of 17 MFA.
Yes,
why is it passed over?
My lord, in the morning session, they were not present, my lord, before the court. There is a contributory negligence is there in this case, my lord.
17, admit post final hearing. It's coming up in final hearing. But then list this matter in June.
My lord, it will be taken in this month, my lord, because they have taken almost 7 to 8 adjournments, my lord.
Finally, list on 22nd. No further adjournments.
Serial number 48 list one urgent ಆಗಿದೆಯಾ? sir?
List number 2 ಏನ್ court officer?
ಯಾಕೆ ಇಷ್ಟು ಮೇಡಮ್ ನಿಧಾನಕ್ಕೆ ಹೇಳಿ ಕೇಳಿಸುತ್ತೆ ಮೇಡಮ್, ನಿಮ್ದು ವಾಯ್ಸ್ ತುಂಬಾ ಎಕೋ ಆಗುತ್ತೆ. ಹೇಳಿ ಏನ್ ಬೇಕು ಹೇಳಿ.
ಸಾರಿ, ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಏನ್ ಮಾಡ್ತಾರೆ?
ಲೋಕ್ ಅದಾಲತ್ ಆಯ್ತಲ್ಲ, ಮಾರ್ನಿಂಗ್ 10:30 only it is called out and all the matters except where the advocates are submitted, all the matters are referred to lok adalat.
Okay, thank you.
What of sir?
ಹೇಳಿ ಸರ್.
ಇದು ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ 48 ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಇತ್ತು.
ಅದನ್ನೇ ಹೌದು, ಇವಾಗ ತಗೊಂಡ್ರಲ್ಲ 22nd April 48
ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ ಮೇಡಮ್?
ಈಗ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡ್ರಲ್ಲ 1:30ಗೆ ಅಡ್ವೊಕೇಟ್.
Date ಕೇಳಿಸ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿ.
22/4/22 22nd April.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಯಾವಾಗ ತಗೋತಾರೆ ಮೇಡಮ್?
List 2 morning 10:30 ನೇ ಕರ್ದಾಯ್ತು. List 2
ಎಲ್ಲ
is taken up at 10:30.
ಮೇಡಮ್ ಎಲ್ಲ ಲೋಕ್ ಅದಾಲತ್ ರೆಫರ್ ಆಯ್ತಾ?
ಸ್ವಲ್ಪ serial numbers where they are submitted not to refer to Lok Adalat. Such matters are urgent post usual course. Other matters are referred to Lok Adalat.
Okay madam, thank you.
ನಮಗೆ ಇಷ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ನಾವೇನ್ ಮಾಡೋದು? ಎಲ್ಲಿ ನಮ್ಗೆ ಇಷ್ಟು ಕೊಡ್ತೀರಾ
ನಾನು ಯಾವಾಗ ಮಾಡೋಣ ಅಂತಾನೋ
ಇದು ಹಾಕೋ ಬಂದಿದ್ದೀರಾ? ಅಮೌಂಟ್ ಹಾಕೋ ಬಂದಿದ್ದೀರಾ?
ಎಷ್ಟು ನೆಲಕ್ಕಾಗಿದೆ
ಎಲ್ಲಿ ಕೊಟ್ರು ಮೇಡಮ್?
ಕೊಟ್ರಲ್ಲ ಅವ್ರು ಇವರು ತಂದಿಟ್ಟೆ ಇದೆಯಲ್ಲ
ಕೊಟ್ರು ಇಟ್ಟೆ ಇಷ್ಟಿಲ್ಲ ರಘು ಎಲ್ಲಿ ಅವ್ರನ್ನ ಕೇಳು. ಬೇರೆ ಎಲ್ಲರೂ ಇದ್ರಾ? ಸರಿ,
That you can take it.
ಅಲ್ಲಿ ಕುತ್ಕೊಳ್ಳಲ್ಲ ಅವ್ರು. ನಿಮ್ದು ಒಂದು ಲಿಸ್ಟ್ ಇದೆಯಲ್ವಪ್ಪ?
ಅಂದ್ರೆ ಹೆಸರು ಗೊತ್ತಾಗಲ್ಲ, ಎಷ್ಟು ಮಾಡೋದು ಹೋಗ್ಬಿಡ್ತೀವಿ. ಇನ್ನು ಹಾಗೆ
Passed over, only 2 matters. Passed over matter, CL number 32.
I am for,
My lords, I appear
I am for
for
respondent to 32.
I appear in the 32.1, my lords. I appear for the respondent number 2 to 4, my lords. Thirty-two, my lords.
accepted for consideration. Serial number 1.
My lord, may I make on submission, my lord? May I make on submission? Serial number 16 is settled, my lord. Serial number 16 is settled.
1,24,000. And which I have first satisfied. And which I have first satisfied.
Next matter is also connected matter. Next matter.